like to call the meeting to order. We could begin with the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Governor, how are you?
Okay, everyone has the meeting minutes for the last meeting in their packet. We have a motion to accept the minutes.
So moved.
Second, okay. All in favor?
Although,
All right, ayes have it.
in the packet, minutes is supposed to be.
Yeah, it should be on the left side. That should be the meeting, the minutes of the last meeting.
Oh. Yes, yes. Yeah, no, that's why I was looking to see, but we really didn't do much last time. So yes, I stand with my motion.
All right. All right, do we have any new correspondence? No? Okay, then we will move on to the presentation from Mr. Michael Jones, the Deputy Executive Director of the New York State Liquor Authority. Oh, yes, sir. I guess wherever makes you most comfortable.
All right. How about you?
Sure.
Hi, Michael Jones, Deputy CEO of New York State Liquor Authority, and I asked for this opportunity to speak with everyone because the community boards throughout the city sometimes have difficulty in understanding their roles and what they're supposed to do and what they should be doing during the process. So I thought it'd be good to have all the community boards at once, and I'm here to answer any questions that you may have. And so why don't I just start off with the basic generalities of the rules of what the SLA does and what we don't do. The Liquor Authority basically regulates the consumption, sale of alcohol in New York State. People may not realize when they have parties, you're more than likely need a permit of some sort from the Liquor Authority if there's alcohol. It doesn't have to be sold, it just has to be consumed on a commercial premise. And I actually was surprised to find out when I had my daughter's 6-year-old birthday party at the community room in our area at 10 in the morning. And they asked if I was going to have wine for the adults. And if I did, I needed a permit, and they were right. They all said I couldn't get one, but they were wrong on that. So generally, we have, at the SLA, there are 4 different bureaus. We have licensing, enforcement, the hearing bureau, and so I feel like Rick Perry. Counsel's office. Don't want to forget that. Licensing, they're the ones that review the applications and send out the licenses. Enforcement, that'd be the investigators. They will go out and investigate potential violations. If they find violations, they'll forward it to counsel's office, to the attorneys that will draw up notice of pleading, it's called, and they'll bring charges. And then the hearing bureau are the judges, the ALJs, who hear the evidence, and they'll decide whether there are violations or not. And if they sustain the charges, it's sent to the SLA full board, which is the chairman and the 2 commissioners, and the 3 of them will decide what penalty, if any. They also decide whether to issue licenses in places that are contested, where there's objection from the community, and or any other objections. So I guess the community board's role mainly is with the issuing of licenses. We do, if there are enforcement issues, we love to hear from you, because you are the eyes and ears. If people are complaining to you, I do accept the complaints by email, and then I'll send it to the enforcement division. But the main role of community boards, I guess, would be the licensing process, where the new applicant will notify the community board, and then they have to wait 30 days before they file. And it's during that time that the community board is supposed to arrange time to meet with the applicant. And there are different types of licenses. There's the we refer to as an OP, that's the on-premise license. That's where people will drink on-premise at your restaurants and taverns. And the off-premise licenses would be your delis, grocery stores, and your liquor stores. The off-premise licenses do not have to notify the community board when they apply. Generally, there are rarely issues with the delis, but liquor stores sometimes can be a problem. And the way they notify the community is by putting signs in their window. And if the community board has objections, we will accept those and be part of the package. We always like to hear from the community board, just that it has different legal significance in certain circumstances. There is what's referred to as the 200-foot rule and the 500-foot rule. The 200-foot rule is a full liquor license, that'd be an OP or a liquor store, cannot be within 200 feet of a building that's exclusively used as a church, or should I say a house of worship, or a school. And there's legal definitions, and there are ways that some people have been able to get around it. It has to deal with entrances. They refer to main entrance or entrances that are used by the public. So exits don't count. Sometimes we'll get a call and there's a door, but it has no handle. So obviously it's not an entrance. So what I usually tell the community boards that your role in that situation is just really to notify us that there's a potential 200-foot issue. But after that, there's really not much you should be concerned about, because either it is or it isn't. If it's within 200 feet, we cannot issue a license. There's no discretion, and if for some reason it was issued by mistake, we're not supposed to renew it when that license period is up. But again, we usually send out an investigator, and we figure it out. But if it's 201 feet, then we cannot use that as a factor in determining whether to issue a license. There's a case, I guess Court of Appeals case, which specifically said that. Because when I started, I was like, gee, 210 feet. That's not a great idea. 200's illegal. What? And they said you cannot, because the statute reads 200, and it's like a 315-foot ball in right field Yankee Stadium. It's a home run. They don't care. 200, that's it. They didn't say 210. So at times I'll get letters from the community board, we're opposed to 200-foot rule. Okay, it's 210 feet. Now we can't, if you're really opposed, we need more specific reasons other than the 200-foot rule. That gets to the traffic, and well, getting ahead of myself, that the 500-foot rule cases are the ones that the community board really, the statute requires us to take the community board's view. The statute reads the SLA shall issue liquor licenses. We're basically similar to DMV. We're supposed to hand out these licenses. The presumption's in favor of the applicant, unless good cause could be shown why they don't deserve it. That's basically all your licenses. The others that I described, the beer wine licenses. By the way, the 200-foot rule does not apply to beer wine. So you can't have a restaurant serving beer and wine directly across the street next door to a church or school. Back to that, the building has to be exclusively used. And what happens a lot is if there are a couple apartments upstairs that they rent out, well, then it's not exclusively a church or whatever. And the exclusivity is one way that the building is no longer subject to the 200-foot rule. But the 500-foot rule will shift the burden from to the applicant to show that it's in the public interest to have this full liquor OP license. Now, 500-foot rule is 3 or more, so the fourth bar within 500 feet, that's a circumference, or as a crow flies, We now have GIS system on our website, which has all the liquor licenses. If you put in an address, and it'll show up on a map, and you can see how many liquor licenses in a certain area. And on the top, it says report. If you press report, it'll print out a report of all the full liquor licenses, the liquor stores, and the church or synagogues within 200 feet. It's very helpful. I use it all the time. But just a lot of times it's difficult to find. We get complaints about Murphy's Bar, but our system has the corporate name and a different address, and it's tough for us to figure out. But now with the GIS system, if I get the right address, I'll be able to find it. And it has round red circles are the OPs, blue triangles are the delis, and a lot of our website actually could answer a lot of your questions. But back to the 500-foot rule and hearing. If they wait their 30 days, they file an application, we hold a 500-foot hearing 15 days after we receive the application, and we notify the community board that the hearings will be held on this date, and at that time, the applicant must show why it's in the public interest, and the community board can make any objections. They could show up and appear at the hearing, testify, but we do accept written, which most places do, written resolutions. We'll read it into the record, and we'll adopt it. Now, if there's community board objection, that application will be sent to the SLA full board. As I mentioned earlier, it's the chairman and 2 commissioners, and then there'll be a full board hearing date where if anyone wants to object again, they can show up. It's open to the public, and they could voice their concerns. And then the SLA full board will decide whether to issue a license. And the statute reads on the 500-foot cases that the SLA shall consider the community board's recommendation, or there's language in there that we have to listen to your recommendation. However, it's discretionary. We, 95% of the time, will adopt with the community board. Generally, we do it all the time. On a rare occasion, they may overrule. It seems that most of the issues now have to do with hours. A lot of times, community boards want to limit the hours. And outdoor spaces. Anytime there's an outdoor space, it's probably going to be a problem. Rooftops. So what we need from the community boards is each application has to be looked at individually. And if you're going to object, I want objections to this applicant or this application. Other community boards have in the past just sent general, it's oversaturated, there's a moratorium, deny this license. There is another case in the mid-60s which says moratoriums are illegal. We cannot enforce that. Community boards, you have the right to say that, but you don't get sued, we do. So basically that letter doesn't help. There are factors in the statute which you could point to. I think it's traffic. I can't remember all of them right now, but you could mention noise in the area, and other factors that you could attribute to this specific location and licensee, then we're able to enforce that. Now, if it's not a 500-foot case, that gets back to where we have to show good cause, shown why this applicant or license shouldn't be issued. It's a pretty tough standard. But what I've seen is situations where the applicant themselves are really not qualified. If you could attack the applicant, saying a lot of times there's inexperienced people, but the guy owns 2 other bars, but those bars are problem places. So based on those reasons, we could deny an application that's either a beer wine or not a 500-foot. But I said it's a little tougher for us to deny applications in those circumstances. Enough me talking. Why don't you guys?
The 500-foot rule only applies when a 4th establishment attempts to get involved.
A full OP, right?
Right, the 4th one.
One within 500 feet in the 500-foot.
The first 3, there's not an issue.
No.
Just want to clarify that.
And there are bars that are grandfathered in before '93. So if this location was licensed and they want to do a transfer, the 500-foot rule wouldn't apply if that bar was there, even though there's 20 bars right next to it now. And there's another, transfers. It's kind of a transfers, a misnomer that people may not know, but you can't sell a bar. You can't just, I'm leaving and because in Lower Manhattan, they'll advertise bar for sale with a 4 a.m. license. It's a big deal to have a license that allows you to sell down in the Lower East Side now at 4 a.m. Because Community Board 3 for years has been tightening it up for 2, same as Community Board 2. So, it's a grandfathered license, but that's not how it works. The license is the location as well as the individual. So, it's similar, I don't know why people don't understand this. It's like, me giving an 18-wheeler driver's license, here, take my truck, No, you can't give away a liquor license. But some people think, well, that's another issue when they start running the place and it's not their license. That's called unveiling. But what can happen, though, is they get a temporary permit and they operate under the existing license until the new owner's application is reviewed, and then they have their own license for that spot. That's how the transfer works. Another way that there's a change of ownership, where you don't change the license, is the sale of assets or corporate change. And that some were pulling a loophole. The disadvantages, like to avoid a 500-foot hearing down in Lower Manhattan, they'd buy 100% corporate change, and the new owners would show up, and the existing license would continue. It's risky for the new applicant because he doesn't know status. You don't know what debts you're taking on, as well as the history of whatever disciplinary history they have. But you do avoid, it's not a 500-foot issue anymore because it's not a new license. But a couple of years ago, we passed, or helped pass, the community board will be notified if the sale of assets is more than 80%, because basically it's a change of ownership. Again, on those issues, though, we're limited to the corporate change issues. So if you don't want this place to change hands, you can't bring up, well, I guess you can bring up the noise and all that stuff, but we're only looking at this new owner. So if the new owner has a bad history because of his other places, then we could deny the corporate change. But again, that's something we just started a couple of years ago. Do you have any questions? Yes?
If the applicant applies under an old name, and so the community board approves it, and then it's discovered that that's not the actual name, that they went under the earlier license, is there anything we can do in that case?
I'm trying to, what do you mean when they apply under the old name?
We had a case where the bar used a name that had been the previous bar's name under their application, but on their business they put a new name, and they came to us in a new name. So we didn't know that they were still operating under the old license.
I'm a little confused. Doesn't sound legal to me, but
Well,
it's,
they
I mean,
actually
typically you'll have a
changed
new
their
corporation, but they keep the DBA.
Right.
I mean, if you want to have a change of ownership, but you still want to be known as Chug-a-Lug Pub, it's always been there. But we're going to change now, so you can keep that DBA, but if it's a different entity, it should have a different name, corporate structure, or so you're saying they're keeping the same corporate name but changing the DBA?
Well, I'm not 100% sure, but it's on the bar itself. They actually changed it back to the old name.
Yeah. Okay.
So
They
there was a problem with the name.
Oh.
Is that a violation in your eyes? in the eyes of the state liquor authority?
Not if they tell us. I mean, it's just a matter of disclosure and openness. Like the Limelight, you're familiar with the Limelight? Well, it's a notorious bar in Manhattan,
Right.
and I think a new group came in and they want to call it the Limelight again. And I don't think the community board objected to that. And there's another one, Bungalow 8, another place that was shut down.
That's the church.
Yeah, on that
Yeah,
stretch.
yeah, 21st Street, 6th Avenue.
Yeah.
Know my boss.
But I'm not entirely sure. It's similar to DMV with the license plates, you know, they could deny certain names and things like that. I don't know if we could do that or we do. I don't think if we do that. I guess there's certain limitations. They had an issue with cheap shots out in Queens. I think it was more the silhouette of what appeared to be a naked woman, you know, on top of the awning was a bigger problem than the name. And I think we looked into it. I'm not sure. You know, it's another a lot of the problems and the issues that arise are something that's really not our primary jurisdiction.
More police matter?
Well, your bad stuff, criminal acts are police matter. Yeah. And noise typically is DEP. They're the ones that will take care of the stereo, the DJs, that type of noise. Noisy people, I think, is the police again. And I was just on the phone with the detective from Staten Island. They're talking about sidewalk cafes. If you have a sidewalk cafe, Consumer Affairs issues the permits for that. We have to approve any alcohol being served, but they have to, you know, get the approval from DCA before they apply for the alcohol. But they can serve food and not alcohol if they don't have our approval, but, you know, there are times where they have the sidewalk. Any other questions?
I got a question.
Hi.
Jones, I'm from Senator Land's office.
Oh, hi.
In your opening remarks, you said something about that typically delis aren't really much of a problem. I know
And getting a
that-
license, the application.
Oh, I know, yeah, right. So my,
No, there are problems selling to minors.
that's the big question.
Yeah,
So what
right.
does your office do about those kinds of investigations? Because evidently that is a problem here in Staten Island.
It's a problem.
It has been for a while, and I know that the police department does their own investigations where they use like auxiliary police officers who are underage and stuff like that. But what do you all do about it?
We do that too.
You do that too?
Yeah.
And what is is there a fine for these folks, or
Yes.
what's the accountability for that?
First time is 2,500, 3,000. Second time be 5, and third time is probably 10,000 cancellation. And yeah, it's self to minors is it's our homicide. That's the,
Did you get that, I guess, based on allegations or complaints by the community? Is that
We,
what
we'll use that. We work closely with the people because they have the auxiliary officers available, and they typically will go to these places and do some operations. And those are the ones that they'll send us the referral, and we'll send a notice of pleading. And those are the easiest or the best for us to prove. It's difficult. On occasion, I've seen where we show, let's say this bar serves some minors. We'll call it in the wild. Typically, the police will show up, they freeze the place, and they try to get everyone's identification. And, those are tougher to prove because sometimes they don't have all the information from the underage kids. And when we go to a hearing, we normally don't produce the kids. So that's why a sting operation, if it's a place that sells to minors, it's better for us to put an auxiliary who we know and have all information themselves. But again, sale to minors is probably the most serious charge that we enforce at the SLA. In addition to after hours, don't like after hours. Matter of fact, selling to 15-year-old kids at 5:30 in the morning is a bad business model that some places like to do. This place in Brooklyn, Temptations. They insisted on staying open until 6 in the morning. And hey, look, I'm making a lot of money. Well, yeah, the rest of the world closed at, well, New York, 4:30. But, yeah.
Regarding the issues that were just raised and issues that bars may have with serving underage, do you recommend that we tell people who come to us at a board meeting to go to the SLA or to the police department to raise those issues? What should be the first line of,
We have joint jurisdiction. I encourage anyone to tell as many people as they can. We have on our website online complaints where people could file them online. We have a phone number. We have someone who takes the complaints over the phone. If they're going to be from the general public, I review most of the complaints, and I have to prioritize and have to look at it. Generally, when the police department sends referrals, that's a problem. Police department referrals are pretty much on top, because there's usually criminal activity. The community board is right after that. When the community board sends me information, I assume that they've vetted it, they looked at it, and
Right.
they're getting more than one complaint. It's just
Right.
not some crank upstairs. And then we get complaints from individuals who are willing to leave their name, and they give specifics. I get the anonymous, they sell to minors all the time. Then I got, my name is Mary Smith, my 19-year-old daughter came home blind drunk. She was at the bar on Saturday night between 11 and 2 because they have happy hour and they sell to minors that night. Now, at least there's enough there that I can look at it and make an informed decision. If I'm going to do something, I know the night, and here's someone willing to give me specifics. But that's, we do our best to, with what we have. Any other questions?
Yeah, Mike.
Yeah,
Regarding the operational hours,
right.
how seriously can you enforce those?
We-
I mean, like, we recommend to all of our applicants that they're home by 2 o'clock on the weekend.
Some-
And most of them agree in
Right.
writing to that, but, you know, there are those that don't. But if we send that recommendation to the SLAs, that's something you guys look at?
Yes, absolutely. As I mentioned earlier, if it's a 500-foot case and it's part of a resolution, we more than likely will follow that, or we'll have them explain why. We have a full board meeting every 2 weeks. That's with the chairman and the 2 commissioners listening. I mean, frankly, I think we should put it on one of these cable stations, and it's better than any reality TV show I've ever seen. I mean, the things that go on and things that people say, it's, you know. But what they typically do is there's opposition. They'll go to the full board, and the chairman or someone will say, well, you know, the community board says, you know, want to close at 2 on the weekend. You say you're going to be a restaurant, white tablecloths and all that. But you say you have to be open to 4 in the morning. So why do you have to be 4? Oh, well, you know, people go out, you know, they start dinner at 1:30. They're going to be a nightclub, and they're going to have all the problems. But, you know, it's funny to watch them try to get over on us. But, you know, if you're a restaurant, see, the problem I have, all I ask everyone to be truthful and do what you're going to say. And, you know, don't go to the community board and say you're going to be a restaurant with a chef and a full kitchen. And then open up, and we do it all the time. We send investigators. They don't have a kitchen. You know, they walk in and, where's your kitchen? Oh, we don't have it. Where's the menu submitted? Where's the French chef? And basically it just turned into, you know, a frat party. They're just selling booze till 4 in the morning, and there's not even, I actually went to a place, it was in Manhattan, they were playing beer pong, and, which is illegal, it's an unlimited drink offering. But I was there with someone else, and he's like, hey, I'm a little hungry, let's order some, can we have some fingers? He goes, we don't sell fingers. Well, come on, any little bar food? No. It's all right, how about pretzels? Nah, no pretzels. They didn't have pretzels, they had nothing but a cake. I mean, that's a frat party and beer pong. As a side note, my nephews were there. They drove in from Long Island, and they came 22nd out of 86 6 contestants. And it was in the afternoon, so I called my brother-in-law. He's like, yeah, you know, they were kind of singing and hugging each other. And maybe they don't like each other that much, but that's the effect of beer pong. That's why we're not, well, I guess it made them nicer, who knows. Oh, and as community boards, what I would like to see is correspondence as much as possible. Just going through it today, kind of a problem. Because there's some unscrupulous representatives. I can't really blame the applicants because normally it's one time for them. But we have people that do business with us on a regular basis. And they've submitted forged documents. They've submitted a C of O for the building down the road. I've seen one recently, whiteout. Haven't seen whiteout in 20 years with the computers, you know. But, you know, it was funny. The original we did, you know, it said it was going to be retail. It was, I think it was a dress shop. It's commercial, but we prefer eating and drinking establishment. So I showed up the next day. Same thing. It said eating and drinking. And I only bring that up because what they'll do is notify you. They won't show up to your meeting. Then you'll say, please show up this one. And they won't show up to that one. But then they file with us. So their application's pending with us, and they're not showing up and cooperating. And then we review it. We don't have anything in the community board because you didn't meet with them, but we don't know that. And then we issue a license. And then the community board will mention that, you know, that they're coming, you know, and it's, if we could start, if it's just conditional approval, we could probably start it. So what I tell the community boards, if someone gives you notice, shoot us a letter to some saying, this person gave us notice. We plan to meet them on a certain date or whatever. Please do not do anything with this application until we meet with them, if that's the case. I mean, if it's something that you don't care about, that you're not going to object to, then there's really no reason to slow the process. But if you see, the one I had in mind was a backyard area was part of the application, and that's going to be a problem. And they said, no way are we going to let these people use the backyard without talking to us first. But they skipped 4 meetings, and they filed with us. And we did send out the letter. Luckily, didn't pick up their license, but we were able to prevent them from using the backyard. But we need letters. And the reason why the community board's not meeting with them, especially if they request the adjournments. Otherwise, we really can't. The statute says 30 days, so you're really supposed to do it within 30 days. Now, if you're not meeting this, but you're going to meet in 2 weeks, that's fine. But if they file in June and say, well, we're not meeting to September, I don't think we can hold it up. That's 3 months of someone who is probably entitled to a license, and, you know, some people paying rent and all that.
And we might get applications like that, but their representative usually doesn't show up, and then at some point has the applicant call speaking in broken English that they didn't understand anything that was going on. It's usually the same guy who represents most of these places.
Neil Vazaki?
Yeah.
Yeah, he's Staten Island, yeah.
You know, and
He actually is one of the better ones. But I was thinking, he didn't come to mind, but I've seen so much work.
I mean, he may be good with regard to.
Oh, compared to the rest, I mean, it's like being the smartest guy in the Jerry Springer show.
He knows our position clearly, and he stands on his head to get his applicants to avoid our position.
Yeah, they're a savvy bunch.
Oh, yeah.
That's yes,
I mean, I'm
I
just
stole that
asking,
from
what
the
do you
South
do-
Park episode.
What do you do if something like that happens, when you get the call after the meeting has occurred? You know, we didn't understand what the words on the page said, you know, please give us the, you know. how do you-
Well, we need to know. You just send it to us. I'll we'll figure it out.
Okay.
You know.
Gotcha.
Yes.
I was going to say, can you possibly elaborate a little bit? The side yard or backyard, if it's a separate lot, you need a separate license. If it's the same lot, depends on C of O. If it's a parking lot, you can't use, it has to go through you, and you decide for that.
We allow people to serve and drink alcohol on areas that they are legally entitled to use. So
But if it's
see, that's where it gets a little, the C of O issues where the backyard, I mean, I'm going through right now, where certain parts of the building are, but not the backyard. But we're not buildings, most of my people don't understand the stuff that's submitted. If buildings has violations, then we can enforce that under, when you file an application, we make them swear that everything's in order and you're complying with all the rules and ordinances. So if they're not entitled to use that backyard area, well, that's a violation, that's how we get them.
Because if you say yes, and buildings is saying no because of the C of O,
Right.
it's contrary,
Yeah.
now you get tangled, entwined in two different laws.
Well, yeah, then we could, if it's intentional, we could charge it with material misrepresentation in the application. Because when they pick up the license, we make them sign another document, say, everything's in order, you swear everything is true and accurate, and you're entitled to.
See, at Community Board One, what we do is, we try to make it easy for you fellows.
Thank you.
We really do, because I know you're busy up there.
80,000 licenses.
If we get something along that line, we have the access to buildings and different.
Right,
things.
right, sure.
So we decide for ourselves, and then we send a letter of non-support and notify.
Well, that's a great example, yeah. So if this application is pending and you said, another thing is, you mentioned that our research shows that the CLO doesn't entitle to the back. So it gives a red flag to us to investigate further and make sure that they don't file a CLO.
On St. Patty's Day, we encourage some of the people want to use an extension of the building, extension of the property. I always tell them, well, it's expensive, so they have to make sure that they are going to make money. They have to apply for the temporary permit. One day fair. And some of them do and some don't.
It's, we have made
It goes
arrangements.
to the PD.
Yeah, the one-day permits are for beer, wine only, and that's what, anyone could apply for one, and we normally issue to anybody, but it's just beer, wine. If a restaurant wants to serve hard liquor, then they have to use their license, and that's typically a caterer's permit. The one-day beer, wine permit is only $38. It's not a major deal, and they just have to apply for it. They have to tell us the defined area where the alcohol is going to be served, the security measures, and we notify the PD. And it's a 1 or 2 page application, and the PD doesn't object, and they give us a security plan. We'll issue it normally. Oh, I have with me some handbooks that we give out to the licensees. And I guess community board should be aware. I also have, I thought I'd grab more, but I have 2 Arabic and 1 Mandarin. Any? Yeah, here.
We can use one of the Arabic ones.
All right. I have 40,000 of these in a storage room next time, so please, anyone needs them,
Do you have another English one?
yes.
Thank you.
We have a pretty significant population of Muslims who own.
All right.
Joe, could you take some for the area chairs who aren't here, the English versions?
It's English and Spanish.
So I guess, Mike, just to finish up, I just want to get it clear in my brain. If a board approves, somebody to get a license, close at 2 o'clock, and then after the license is achieved, and they decide that they want to use what used to be their parking lot as an outdoor seating area and service area.
Right.
Is that something you would look at?
Yes, that'd be an alteration. Community board's notified on alterations. They're asking for an extension of premise. And then the same rules would apply. I mean, is this area, is it a place that can get a license? And do they have ownership and is it proper for them to serve there? And if that's the case, we will review the alteration application and the CB can comment. Now, generally, I thought it's probably true. If it's a 500-foot case for the main license, when you're doing an outside area, you're not going to get a 500-foot hearing. It's not a 500-foot case. But if there's objection from the community board, that alteration application will go to the full board. And they'll take into account that the underlying license is a 500-foot case. So, to have this outdoor area, we're going to factor in the 500-foot issues as well. And it makes a difference. But that's typical the way many people are doing it now, is they want the license right away, so they only do the inside part. And then within a brief time, they'll apply for the outdoor areas as an alteration.
Thank you.
Yes?
It's interesting, when you began, you said you regulate the consumption and sale of alcohol.
And the manufacturer.
Yeah, the reason why I raised that, on the south shore of Staten Island, we have some estates, some larger homes, where people regularly have parties with 40, 50 people in their backyard, drinking large amounts of alcohol. And neighbors get very upset and they come to us as the board. When you said consumption, that rang a bell here.
Right.
What, if anything, is your involvement with that?
That's a private property, though.
So
that's
private
definitely-
property,
yeah.
so that we call the police regarding noise
Yeah,
and
that's
other
right,
kinds of
disorderly
issues.
conduct, noise stuff, yeah. I think I mentioned commercial,
Okay,
a commercial.
I just want to
If there's
clarify
a-
that.
If someone's making money on renting his house,
Okay.
so, I mean, if it's someone's house, but they're renting it out for people to use, it can apply. And then is that a public event or a private event? Is it, someone's birthday party, or is it, on the internet, come see DJ whatever at this guy's mansion? And that's where it gets a little confusing.
Speaking of consumption of alcohol, do you want to mention anything about the Dram Shop Act?
I don't know, it really doesn't apply to us. It's a civil.
Yeah, I know, but it's
If I were a bar owner, I'd be concerned
applies-
about it.
It applies to all license holders, that you issued a license, that license holder, if they overserve,
Right?
serve someone already intoxicated, that person goes out and causes serious physical injury, likely to die or dies, it goes back to the license holder. For the Dram Shop Act actually allows civil prosecution.
Right.
I used to investigate those cases back, and most attorneys don't touch that, but some do, and they go for deep pockets for those cases.
Right. I mean, you're gonna get run over by a guy with no insurance. It used to be
Well,
10-20, but now what is it?
It involves the
25?
SLA in a sense that how many violations of this nature have been issued to that license holder? Did you revoke the license? No. Second time, did you revoke the license? Possibly no. Third time, there's a death. Well, now the state's involved.
Everything's fact specific, and there is a case, a very terrible case, I think 8 people were killed, where we did revoke the license, and the Court of Appeals reinstated it, saying it was too drastic. Those over-serving cases are very difficult for us to prove. It's nearly impossible, because we need evidence that the bartender over-served that individual. So if we're not getting cooperation from a bartender, we're not getting people that could testify that they were visibly intoxicated on top of it. There are a lot of people that could drink a dozen martinis and walk out of the bar, you wouldn't know. Those are nearly impossible for us to prosecute and prove, because we don't have the resources. Well, not only manpower, people aren't going to come to the SLA. When people are killed, the DA's office and cops will go there. They subpoena people, and they're going to testify for the DA. when I call up the same people, say, hey, come up to 125th Street, testify at administrative hearing, they're just not as willing.
Court order subpoena of.
Yeah, we-
Yeah.
We can do that. Again, we rarely have that evidence that they're visibly intoxicated. I mean, it's a terrible thing that they do, and the results are terrible. But the over-serving is, that's why sort of broken windows. If they're selling to minors, there are a lot of things going on. You know, if they're over-serving, that means there are minors there, and there are a number of other things happening that we can. Matter of fact, some of our worst places with the real violence. Now, violence is another thing that's difficult for us to prove because beer garden, I think, is the case. Well, we have to show that the licensee suffered and permitted is the language. Basically, it has to, that the manager or someone in control is aware that the fight's about to happen, and they do absolutely nothing to prevent. Otherwise, which generally I think spontaneous fights can happen, and then the licensee is not responsible because it was spontaneous. What we have is the 118 focal point law, which if the police were to give us 6 referrals within 60 days, then there's a presumption that it's a bad place. We no longer have to get into the suffering and permitting. So we don't care. You had 6 spontaneous fights in 60 days, you're a bad place.
118 more.
118, yeah, it's called focal point. And that 6 in 60 is a presumption. So if you have 4 in 60, we could still charge it. Matter of fact, some other places it was 4 over 6 or 8 months, but they were very terrible things. And it was a small town out in Suffolk where the 12-man police force, 4 of them had to sit outside this bar every Friday and Saturday. So, you know, that's just, a focal point is a drain on the resources. That's all it is. If I have a lieutenant come in and say, yeah, we have to put a whole squad out there in front of this bar, it's just not fair to the whole community to have that drain.
We had a problem with the bar, it was no longer in existence when Forest Stadium years back. And we had 400 to 600% increase in police presence. In the meantime, someone was firing off a gun in Mariners Harbor, and everybody was up here.
Right.
The task force that wanted to go because of this bar. So once I chaired the meeting, I got main member of the community to sit with main partner of the main owner of the bar and iron out the differences, and that resolved it. Well, shortly thereafter, they closed up anyhow, but
Yeah.
not a bad thing.
Right. Yeah, there's certain locations which, back to the remedy is fines, that's what we give fines, or we could cancel a license, which means they can no longer sell. We could revoke a license, which means they can't sell, and the operator is not allowed to apply for another license. So revocation's a big deal. And then there's revocation and prescription is what you describe. It's a bar that this location is bad. So it doesn't matter who's there. So we'll revoke the license and prescribe that location because it's always going to be known as a drug den. And that is rarely used because basically it denies the landlord the right to lease his place, you know.
You would issue a letter of warning or a reprimand?
We issue letting warning all the time. We issue letters of warning all the time.
Yeah.
Generally, it's the first line. When we get complaints, the anonymous one's the one where I really can't send someone. We'll typically send out a letter of warning. Say, you know, please be advised that we understand that you're maybe selling to minors. We're not saying you are, but you know, it's brought to our attention. We remind you to, or you're noisy. A lot of times we'll bring in the licensee and explain that there are complaints about noise. You got to do something because many times they do say, "Well, gee, we didn't know. You know, no one ever told us." So we get on the record, we get them in here. You're on notice, and then we'll take it from there.
What we do with the noise complaints, by the second complaint, we call the license holder in and have a sit down.
Well, that's great.
And
That's
document it and.
that's what we do, and
try to give
if you do it,
a
it's even
shot
better.
that way.
Oh, well, available if anyone has any more questions, but I could leave if you guys want me to get out of here.
Do you
As
have
long
a
as-
card?
and I have a card. Just tell me what ferry I'm getting. What, like, every 20 minutes?
Every 30.
30 minutes? All right. Looks like it's 7 o'clock. I have a business card, a couple of them.
Thank you.
Thank you.
Thank you very much.
Yeah. Here you go.
All right. Thanks.
I get his email every day.
Investing them all.
Okay, moving on. Do we have any old business?
Thank you.
No? Any new business?
There's the one Mandarin one.
No. We have a motion to adjourn?
Motion to
Seconded?
adjourn.
Okay, all in favor?
Thank you.
Aye.
Meeting is adjourned.